Hi everyone, it's Marieta, founder of ImmigrationBiz, business immigration attorney, and today I do want to, as promised, give you the recent updates regarding travel ban. So exactly, I'm going to be reading this information from the official source, which is proclamation for those who are interested. So this is going to be a brief video, but I also want to talk about the the recently introduced Immigration Reform 2021, the US Citizenship Act of 2021. And in that part of the video, I will focus on the employment-based category. So it's going to be concerning legal immigrants, okay? Because many of you know that the recent introduced immigration reform is hugely impacting in a positive way the undocumented aliens, in other words, undocumented immigrants, right? But in this video, I really want to focus on those who are legal in the United States or they wish to immigrate, and how is this immigration reform going to impact these individuals. So definitely stay tuned till the end of this video because I'm going to be sharing good stuff here. So let's get started with this proclamation. I made a video recently where I did explain very briefly the proclamation upcoming travel ban actually that was already issued by President Biden. I will be linking the video here for you guys if you need to revisit. So let's talk about the proclamation, and this proclamation was issued on January 25th, and it's called Proclamation on the Suspension of Entry as Immigrants and Non-immigrants of certain additional persons who pose a risk of transmitting coronavirus disease. So this is actually referring to that old travel ban that was issued by ex-President Trump, and it was already rescinded I think few days before President Biden was elected. Now, with this new proclamation is actually imposing a ban to travel and enter United States, especially if you're coming from certain countries such as, here we go, UK, European Union, Ireland, Brazil, and especially it's concerning individuals who were present in these countries during the 14-day period preceding their entry or attempted entry into United States. And also, this proclamation is adding additionally country South Africa, meaning if you were present during the 14-day period preceding your entry or attempted entry into United States, you are banned to enter United States. Now, this is not concerning lawful permanent residents of United States. So even if you spend the last 14 days in these countries, you are allowed to enter United States. Also, obviously, if you are a citizen, also if you are a spouse of US citizen or lawful permanent resident, you can enter. Also, if you are obviously a parent or legal guardian of US citizen or lawful permanent resident, you can enter. There are also additional exceptions such as sibling of US citizen or lawful permanent resident, provided that both are unmarried and under age of 21. Any non-citizen who is a child, foster child, or ward of US citizen or lawful permanent resident who is seeking to enter under these classifications. Also, any non-citizen traveling at the invitation of United States government for purpose related to the virus. Also, any non-citizen traveling as a non-immigrant pursuant to C1D, C1D non-immigrant visa can enter. And also it's concerning obviously these visas categories: A1, A2, C2, C3, G1, G2, all the way to G4, NATO 1, all the way to NATO 6. Additionally, it's also concerning additional people whose travel fall within the scope of Section 11, and non-citizens who are member of U.S. Armed Forces, any non-citizens whose entry would further important U.S. law enforcement objectives, any non-citizens whose entry would be in national interest. And so this is basically the exception, right? Now, if you are obviously under work visa, guys, because this is also a question people ask me. If you're under work visas, such as H visa, L visa, E2 visa, you can enter United States. However, if this is mostly concerning people who are usually within the categories of B visas, right, international travelers, who are being banned to enter United States. Now, this provision, proclamation is in place in effect until terminated by President. So there is no specific date for those who are asking. And the effective day is, or actually was, January 26th. Okay. And here it goes. The suspension and limitation on entry set forth in Section 1A of the proclamation does not apply to persons aboard a flight scheduled to arrive in the United States that depart prior to 12:01 a.m. Eastern Standard Time on January 26th. Okay, so if you were guys already on board, like you were flying to the United States, you were literally in on the plane, this would not affect you. However, if you are entering now, as I'm making this video, is actually January 27th. This is certainly in place. Okay. Now, this was obviously concerning 1A. Now, we have a suspension and limitation on entry set for in Section 1B is going to be effective on January 30th. So let's go to 1B. So let's clarify this, guys. Okay. Here we go. The entry to the United States as immigrants or non-immigrants of non-citizens. By the way, the word non-citizens is a new word introduced because before it used to be alien. Okay, so meaning you are not citizen of the United States. The entry into the United States as immigrants or non-immigrants of non-citizens who were physically present within the South Africa during 14-day period preceding they cannot enter. So guys from South Africa, this is actually implying to you starting January 30th, as we can see here. And the rest of you from Europe and Brazil, it's already in place, it's already effective. But those who are coming from South Africa, this proclamation is in effect starting at 12:01 a.m. Eastern Standard Time on January 30th, 2021. So 3 more days. You can still enter as of today. Today is January 27th. You won't be able to enter US starting at 12:01 a.m. Eastern Standard Time on January 30th, 2021. Okay, guys? So this update is pretty crystal clear. If you have comments, questions, please leave them below. And let's talk about the Immigration Reform 2021 introduced already by President Biden, the U.S. Citizenship Act of 2021. Now, this U.S. Citizenship Act of 2021, obviously this is comprehensive immigration reform, which I'm not gonna dive deeper into all the details here in this video. However, I made a video already where I did talk about the overview of this U.S. Citizenship Act of 2021. I will link that video for you guys. Go ahead, check it out. And in this video, I want to focus on employment-based visas and green cards, okay? Because many of my clients are actually E2 visa investors. Some of them are under L visas, but all my clients are doing business in US. They are all entrepreneurs. I'm focusing on E2 visas because myself, I was on E2 visa in the past. So I've been through the journey myself. As you can hear, I'm already, also immigrant. And I am helping people to establish successful, profitable companies in the US. And some of them obviously have these questions. Can I apply for a green card if I'm on E2 visa? Can I jump from L to a green card? And how is this new upcoming immigration reform 2021 going to impact me? Actually, there was a question asked today by somebody who posted a comment under one of my videos. How is this immigration reform going to impact especially E2 visas, right? So let's focus on that, right? Let's focus on answering these questions for you, because as you know, with, for example, E2 visas, if you want to jump directly from E2 to a green card, there's no direct path, right? So I usually recommend that you do EB2 national interest waiver if you qualify, but not every E2 visa investor qualifies under EB2 national interest waiver. It's a very, very tricky situation with E2 visas. You are allowed to enter US, live in US, manage your business, but it's again temporary visa. In my opinion, this is certainly something that is needed for immigrant entrepreneurs, immigrant investors, because there are basically two options for immigrant investors. One is E2, EB5, or EB2 national interest waiver. And these are not the most ideal solutions, especially for those who, for example, are not necessarily millionaires, right? And they cannot apply for EB5, or there is a backlog with EB5. Or what if their business is still adding value to the US economy, but they are not on that level that it would qualify under EB2 national interest waiver? So in my opinion, this part of legislation is actually missing for immigrant entrepreneurs. So let's talk about these employment-based visas and what is this US Citizenship Act of 2021 addressing when it comes to employment-based visas. Because EB2 interest waiver, national interest waiver, is within this category, EB2 national interest waiver. So it is technically in that category of employment-based visas. EB5 is a specific category through investment where it's not really within the employment-based visa. So as you can see, EB5 are not even mentioned. EB5 category is not mentioned in the US Citizenship Act of 2021. However, they are mentioning the EB2 national interest, EB2, meaning employment-based visas. So, number one, their intention is to reduce administrative burdens and expand pathways for employment-based visas and green cards. So this alone looks like they are planning on expanding the pathway for employment-based visas. So now you probably are familiar, we have EB1 category, then we have EB2 category, then we have EB3 category, right? These are the employment-based visas and green cards, right? And then we have the EB5, as I already mentioned. So here you can already see that they are planning on expands pathways for employment-based visas. Now, I would like to see more. How is this going to look like? And as far as I know, based on today's recent news, I know that Biden is open to actually dividing the bill, and maybe they will be introducing the bill, or maybe they will be voting and they will be introducing sections of this bill, not necessarily the whole thing, which is comprehensive. So they will take it piece by piece in Congress, and we'll see how that's going to unfold. However, here you can see that there is some sort of intention to expand the pathway for employment-based visas. Okay? This is also including graduate of US universities. Now, guys, this was exactly my situation. When I graduated Northwestern law in Chicago, I had difficulty to actually find employment, which was 10 years ago. Market was full of unemployed lawyers. I could not get H-1B visa sponsor, and I was forced to, number one, leave the country, or number two, reinvent myself. And based on that current legislation back then, I decided to go with E2 visa so I can start my business and then run my company in the United States. But think about it, there are many people who don't even understand these options, okay? And that's somehow how I influenced many of my clients, because they were some of them students who could not find employment, and they were, in a way, they started to think in a different way how they can stay in US legally. And because, as we can see, the current legislation is not offering that many options for students, graduates of US universities. Some of these universities are top law schools. I mean, top universities. My law school was top law school, top 10, number 9 these days, actually. And I do have advanced degree as well. And some of these guys have advanced STEM degrees, and they are forced to leave the country because they cannot find employment, or if they do find employment, because there is a cap right now for H-1B visa, only $85,000 a year. that was forcing them to actually be part of this ridiculous lottery system. And if they were not selected in this random lottery, they could not stay in US legally. Many of these people were forced to leave, which is counterproductive for the US economy and for the growth of the country. What's the point of actually inviting people to study in the United States, giving them these degrees from top universities, super expensive school and studies, and then letting them go? Doesn't make any sense, right? So as we can see here, they are planning on introducing some sort of expansion on these pathways for employment-based visas and green cards. Especially they want to focus on STEM degrees because they do understand the value. And I like to see actually further expansion of other advanced degrees, because there is, like I said, there's no point. There's no point inviting people to study in US, paying all these ridiculously high amounts of money and taking these loans to be able to finance this schooling, and then eventually leaving the US. It just doesn't make any sense. Doesn't make any sense for US. Doesn't make any sense for those international students. Okay, number 2, incentivizes higher wages for non-immigrants. So they want to incentivize higher wages for non-immigrants, especially high-skilled visas. So high-skilled visas are basically those right now, those H-1B visas. Those are the high-skilled visas. And as you know, the recent rule that was proposed and right now is frozen for 60 days, the H-1B visa rule, was actually proposing to reward and prefer those higher skilled positions within the level 4 and 3 over 1 or 2, which are the entry-level positions. So they are, obviously, they already introduced a rule that is somehow similar to what I'm reading here, but the rule itself is frozen right now for 60 days. And they also want to reduce the competition with American workers. Number 3, they're intending to protect work authorization for dependents of H-1B visa, which is the H-4 visas, right? So they want to introduce the work authorization. And also, they want to actually protect children from aging out. So this essentially here means, guys, that when your child gets the dependent visa, if you are on H-1 visa, your child can get dependent visa. But this can only happen if your child is under age of 21. If your child is over the age of 21, your child needs to look for alternative solution. For example, student visa, right? But that is forcing your child to actually enroll to school. What if your child wants to start working? Then what? Makes sense? So this is what they want to address. They want to address the situation where your children are aging out and in a way they are being separated from you. Or maybe they need to leave the country. It's just not making any sense for family unit, right? Number 4, they want to enable the Department of Homeland Security to adjust green card availability based on the macroeconomic conditions. Now, this looks like they want to really take a look at the macroeconomic conditions in the country. And based on that, they do want to adjust I don't know if this is going to look like specific green card category or the cap or how that's going to exactly look like. But they really want to take into consideration the value immigrants are actually bringing to the US economy. Okay? And therefore, they do want to adjust maybe certain green card categories and the availability in those categories, especially for those who intend to benefit the economy of US, whether it's like through investment, like EB-5, there is a cap also. And that doesn't make any sense. Like, why would you limit issuance of this $1 million green card if people want to pour in money to your country, right? It doesn't make any sense. There is no logic in it. And lastly, create regional economic development pilot program. I don't know exactly how this one is going to look like, but certainly they're open to adjustments. They want to change the green card employment-based visas and they want to be more flexible. Now, I don't see any way here how these proposed changes are going to impact E2 visa holders unless the changes when it comes to EB2 green card category will be included, and also unless the cap within the EB5 green card category will be removed, so more people eventually could technically apply for EB5, and also unless there are additional provisions how is there expanded pathway for employment-based visas. Like, for example, I would like to see something like for those who are self-employed, who are under E2 visa, who want to start their own businesses, they can easily go to a green card after, even though they are not making millions, because there are many E2 visa investors who are not within that 7-figure category, but they are adding tremendous value to the US market, and they are forced to actually renew that visa every 2 years over and over again, which is not really making sense for people who are already bringing capital to the US, right? And they are adding value, for example. That's number one. Number two, within the EB2 national interest waiver, this is specific green card category for those who are adding value to the US economy, and it is within the national interest of US to actually keep these individuals, and therefore they are waived to actually first submit and apply for PERM, the labor certification, because they are already adding value to the market, right? Labor market, it's a waiver. They don't need that certification from Labor Department because they're adding value and it's within that interest of US. So I made a video on EB2 national interest waiver, especially when it comes to entrepreneurs, right? If you are on E2 and you want to jump to that category, check it out. Those videos are available. Actually, I will link those videos here for you guys. And in my opinion, there is the high level of discretionary power introduced into these specific green cards because, again, if you study the requirements, you will understand that essentially it's up to that officer to determine whether if you submit evidence that is strong, whether you are meeting those requirements or not, especially when it comes to determination of that, whether that is within the national interest, whatever you do with your business, whatever that business endeavor is. Because you don't necessarily have to establish that that business endeavor that you are doing is creating immediate economic impact. You can even establish potential economic impact, and you should be approved. But whenever they are deciding these cases, they are using discretionary power. That being said, they can decide the way they wish, and that's the tricky part right there, okay? Because their decision could be prejudiced. So guys, definitely check out that green card category. As far as I see, I don't see any changes within this green card type here, but we'll see because we need more information how exactly they're going to expand on these pathways for employment-based visas and green cards. Okay, so this is that employment-based visas and green cards. Let me very briefly mention the pathway to citizenship for those who are undocumented, if you are interested. So let me just very briefly give you the overview here. Part of this immigration reform is the pathway to citizenship for undocumented workers. So this essentially means that it's a 5-year path for people who are currently living in the United States and they are undocumented immigrants, meaning they don't have papers, they are there illegally, they are out of status. And here's the requirement number 1. It's a path to temporary legal status or green card eventually for those living in the United States as of January 1st, 2021. So if you were in US on January 1st, 2021 illegally, obviously if you never committed any crime, if you will be able to pass the background check and you are already paying taxes, and you will be able to fulfill other basic requirements, then you will be able to apply for this temporary legal status. Okay, now this temporary legal status will be issued for 5 years, and once this is issued, then subsequent 3-year path from green card to naturalization will follow. So you will have to hold and keep green card for 3 years, and again paying taxes, doing all things right, and after that you will be able to apply for your citizenship. they're also changing the word alien to non-citizen, as we can already see in that proclamation that I was sharing with you today. And this is applicable to 11 plus million undocumented workers, right? Obviously, this does include DACA, which are those dreamers known as DACA within the DACA category, Deferred Action for Childhood Arrivals. And with these guys, basically they will be able to skip the temporary legal status 5-year path, right? And they right away will be able to apply for the green card. And then from that, they will be able to get their citizenship, okay? And of course, it's already including those who are with the temporary protected status as well, and immigrant farm workers as well. Okay, guys, so this is the overview. Now, if you have comments, questions, I do actually want to hear from you guys. Leave your comments below this video. For those who need to book a consultation with me, you are welcome to do that. Link is going to be below this video as well. And I'll see you soon, guys. Stay well, safe, and I'll talk to you soon. Bye.